Whatever the format you use, whether you're organizing around issues, the elements of the case, jury instructions, witnesses, or even chronology, you want to make sure that you follow these guidelines in presenting your closing argument. First, you want to start strong, and you want to end strong. Okay, what happens in the middle? It's like a sandwich. If you have a sandwich with hard bread on the top, bread on the bottom, you can have something soft in the middle. But you want to start strong and end strong. You want them you want to grab the jury right off the bat with your closing, and then before you sit down, you want to have them have something in mind to remember your case by. So start strong and end strong. You want to have in their mind something powerful as the most recent memory. You have a really limited window of time, a very limited opportunity to talk to the jury, and so you want to use that. You want to use that as a lot. You don't want to bore them. You don't want to go on and on and on. You want to have something vivid, something creative, something powerful for them to remember you by. For example, in the firefighter case, here's an example of a strong start, I think, for the prosecution. The prosecution, or excuse me, the plaintiff could say, "Ladies and gentlemen, there was an accident on the night of January 13th, or whatever the date was, and it changed the plaintiff's life forever." Another example of a start from a plaintiff's standpoint might be dealing with undeniability. The plaintiff might say, "One thing the defendant can't deny is that he failed to stop for a fire engine." There's another example. So you just want to paint the most powerful, vivid, memorable picture that you can. The other thing you want to do is you want to argue your affirmative case first. Your affirmative case, remember, is your positive case. You want to argue your case. You want to talk about your theme. You want to talk about your theory of the case. You want to tell your story first before you talk about the other side's case. You want to be positive in your presentation first. You don't want to just be responding to the other side's case. You want to tell your positive case first. The defense always has more latitude. The defense can always begin with a denial and then move on to an affirmative case. You could state a very quick denial and then move on to your positive case. The other thing you want to do as far as a guideline for creating your argument is you want to either embrace or displace the elements. Embrace, of course, is to put your arms around something. Okay? You want to embrace or displace the elements. So the plaintiff will always must address all of the elements of the case. What the defense wants to do is to get rid of one of the elements, or is to show the weakness of one or more elements. You want to take these legs off so that the case falls. Okay? Throughout your argument, you always want to address the credibility of witnesses. For example, in the firefighter case, the plaintiff's attorney could say, "Ladies and gentlemen of the jury, this case is about the siren." Okay? The defendant's testimony was that there was no siren. Well, we can't believe him because there is too much at stake. He stands to lose too much. And then you can always argue damages. Now, the final thing that I want to talk about is really a return to a discussion about the keystone of the case. At the very conclusion of your case, You want to return to your keystone theme. This is part of starting strong and ending strong. The ключевое камень. Return to your keystone theme. The closing is the key to the trial. Okay. So I think that there's some additional information in the manual that I would suggest that you read on your own. This has to do with just a couple of issues, raising objections, and some ethics. Let me just highlight a couple of things on ethics. First of all, we talked about how you should not hide evidence. You should also not misstate evidence. The jury is smart. You can't lie to the jury. You can't hide the evidence, nor can you misstate it. You just need to handle it in a way that's going to be the most positive to your case. Also, you cannot misstate the law. You cannot tell them the law is one thing when it's really another. So be careful about not misstating the law. Also, you need to not to misuse the evidence. You can't make appeals to the fact finder's interest, that is to the interest of the jury itself, and do not appeal to emotion, sympathy, or passion. Okay, with that, that's essentially the points on organizing your closing argument. Let me just make, in conclusion, a couple of comments. First, I want to commend each of you for your willingness to learn a powerful new skill. I want to return to a comment I made earlier about my court. In this courtroom, we handle approximately 10,000 cases every year. Of those 10,000 cases, there will be approximately 10 to 15 cases which will be tried before a jury. Now, when I give you those numbers, 15 jury trials out of 10,000 cases, you may think in your mind, well, the jury trial can't be very important because only 15 out of 10,000 cases are tried before a jury. That could not be further from the truth. The prospect or possibility of a jury trial affects every single case. Every one of those cases has the potential to go to jury trial. And so the prosecutor always has that in mind. The defense attorney always has that in mind, that this case could go to jury. The result of a jury trial can be unpredictable. The jury will decide the case as it wants the case to be decided. The case is not decided by the judge, it's not decided by the attorneys, it's not decided by the governor, by the mayor, by government officials. The jury will decide the case. And so, because of the amount of time expended in the case, the economics of it, the cost of a jury trial, the unpredictable outcome, there are many, many reasons why defendants will either want to plead guilty to settle the case. The prosecutor may want to dismiss charges, but I just can't emphasize enough that the jury trial casts a very powerful influence over the entire American legal system. And I have no doubt that when jury trials are fully implemented in Ukraine, that will be the same in Ukraine. Thomas Jefferson once wrote to a friend of his in France in a letter. He said, "I consider the jury trial as the only anchor yet devised by man, by which a government can be held to the principles of its constitution." I echo that. I want to commend you. Again, I miss not seeing you personally, but I wish you all the best, and if I can do anything to help any of you, we'll have some information on how you can contact me or any of the other teachers, including judges and attorneys from the United States. I hope you'll contact me if I can be of help. And so with that, I wish you well and good luck in your law studies and in your mock trial competition next spring.